Alex here with a video on high conflict child custody. In this video I'm going to cover children providing input to the court. This is something that I hear quite a bit. I get questions on quite often. It might surprise people that in my 2008 to 2016 child custody litigation, my son did not provide input to the court even one time. Neither I nor my ex wanted to involve him. I don't. I think that people don't understand that kids are so impressionable. Even when, like, a lot of people understand that kids can be coached or scared or coerced into saying things because they're kids and they're easy to, threaten or manipulate or whatever. Most people understand that, but most people don't understand that you might not even be trying to manipulate your kids, and it just happens inadvertently because, like, the way they look up to you, and they, your kids want to please you, and so you might, there's so many examples to this, and, like, it's a really deep topic, but I'm just going to really glaze over it and talk about some of the rules that Nevada has implemented recently regarding child testimony in custody cases and such. um, your kid, you could ask your kid, do you want to stay with me more than dad? And they'll probably say yes because they can sense, what they want. They don't want to be, even taking aside, like, being afraid of getting in trouble for what they say, because this is an issue for people with, like, abusive exes. Um, Even taking that aside, they're going to want to, like, make their parents happy, and they're going to want to guess, what you want them to say as opposed to what the truth is. And for really young kids, it's really, the truth is not exactly a clear-cut thing, especially when it comes to their parents. So, I mean, there's some people that'll say, my son or daughter is really smart and they really mean what they say. They really do want to live with me. But you know what? The court doesn't know. The court can't set your kids apart from, the average kid or anyone else's kids, which, like, kind of leads me into the main, like, point that I'm trying to make here is, don't come into court with, like, letters from your kids, and, if at all possible, avoid, like, telling the judge that your kid wants to, come in and talk, and explain what they want. Um, like, the first thing that I would do is I would try to find a way to involve, like, an expert, because I was able to win my motion to modify custody by bringing in experts, and in my case it was a dentist. So my first instinct would be, if your child's input is really important, especially at a young age, then it should come to the court through, the expert testimony of, like, a psychologist. The court will hear kids if they're, like, way older, especially like 15, 16, 17. Doesn't mean they're going to do what they say. I mean, a lot of people are surprised. They think that there's a certain age and then your child can sort of decide who they want to live with, but that's not true, at least not in Nevada. There is a certain age at which point the court has to consider what the child's wishes are. But the word consider just means that. The court only has to consider it. Typically, if your child isn't, like, expressing a lucid, cogent argument as to why they want to live more with one parent or the other, the court will just disregard your child's wishes, because even when you're a teenager, it's really easy to want to, stay with the parent who's giving you what you want, and not the parent who's disciplining you. And this is just an example. This is a really sensitive issue for some people. They get really upset when they hear that their kid just can't come into court and say, I want to live with mom. I want to kind of jump back to what I was talking about with really little kids. You could ask your, 5 or 6 year old, 7-year-old a question, who do you want to stay with? And they'll say, well, with you. And they won't even be thinking about that when the other parent asks them the same question and they tell that parent, well, I want to stay with you. And of course, it could be that I mentioned this, it could be that one's abusive or manipulative. But this is something that the courts can't really figure out just by taking your word for it. You got to get an expert involved if your kid's really young, and if your kid's really old, as I mentioned, old, up to 15, 16, 17, right before they become an adult. It doesn't necessarily mean that the court's going to just say, okay, yeah, this teenage daughter wants to stay with mom, so that's it. No, they're going to say, Well, she talked about wanting to go there for college, and she wants to make sure she can establish residency there. Or, there could be some issues. I mean, I'm not going to go into detail on this. I really just wanted to make people aware that when it comes to your kids testifying, my case was highly contentious, and my son never testified. Not once. Nobody ever even asked. So, I mean, if you think it's necessary, in my case, it wasn't. You can figure out other ways to prove things than having a little kid come into court and say, mom or dad's doing this to me. My ex was doing, my ex was abusing my son, neglecting him, and I didn't need him to come and tell the court that. I was able to get other witnesses, adults, to come in and tell the court that. So the last thing I wanted to mention was there was a recent rule, like a year or two, that came out in Nevada. I can't remember now if it was a statute or just popped into the court rules, but it actually covers child testimony. So when kids are, I haven't read these rules because really they came into play after my case was already resolved. But my understanding of it, when I glazed over them and really briefly looked at them, was that the court has a few situations as to how they're going to have little kids testify in court. And one of them was testify with both parents outside the courtroom, and I think another one was the kids can testify in chambers, which is like in the judge's office. They can talk to the judge. I don't know how this stuff is going to be put on the record, so I mean, that does give me some concerns. Coming from a person who files appeals, if it's not in a record, you can't use it in the next court. So I'm curious as to how they handle that, but it's not something I'm going to look into really deeply, since that I'm just really out of that whole process now. With that, I will end this video, and I'll see you guys next time.